The defense of insanity is a general defense which is available to all crimes. Where a defendant is found to be insane, the jury are directed to give a special verdict of not guilty by reason of insanity, under Section 2 of the Trial of Lunatics Act 1883. This previously meant automatic admittance to secure accommodation. Release was only possible on authority of the Home Secretary. This often resulted in lifetime institutionalization. Mandatory detention still applies where the penalty for the offense is fixed by law. For example, murder. In all other cases, detention is at the discretion of the judge under Section 5 of the Criminal Procedure, Insanity, Act 1964. The defense of insanity is unique in that it may be raised by the prosecution and judge in addition to the defense. Indeed, it is generally the defense seeking to avoid a finding of insanity, and often the defendant will change a plea to guilty to avoid a finding of insanity. The defense has declined in importance and use since the abolition of the death penalty and the introduction of the defense of diminished responsibility in relation to murder. The question of whether the defendant can rely on the defense of insanity at the time of the offense is determined by application of the M. Norton rules. These were formulated after Daniel M. Norton wrongly believed he was being persecuted by the Prime Minister Robert Peel. He killed the Prime Minister's secretary believing him to be Robert Peel. Under the M. Norton rules, it must be established that at the time of the offense the defendant was suffering from 1. A defect of reason. 2. The defect of reason must be caused by a disease of the mind. And 3. The defect of reason must be such that the defendant did not know what he was doing, or if he did know, he did not know the act was wrong. For a finding of insanity, the defendant must suffer from a defect of reason. Mere forgetfulness or absent-mindedness is not sufficient. In R.V. Clark, a 58-year-old woman absent-mindedly placed a jar of mincemeat, a jar of coffee and some butter into her bag whilst shopping in a supermarket. She had no recollection of placing the items in her bag. Insanity requires the defect of reason to be caused by a disease of the mind. The courts have interpreted this widely as to include any physical disease which affects the mental functioning. According to Mr. Justice Devlin in R.V. Kemp, the words, disease of the mind, are not to be construed as if they were put in for the purpose of distinguishing between diseases which have a mental origin and diseases which have a physical origin. Lord Chief Justice Lord Lane in R.V. Hennessy further defined disease of the mind as not limited to diseases of the brain. It means a disease which affects the proper functioning of the mind. Mind, in the words of Lord Diplock in R.V. Sullivan, includes the mental faculties of reason, memory and understanding. Conditions that have been held to constitute a disease of the mind amounting to a finding of insanity include arteriosclerosis in R.V. Kemp, epilepsy in Bratty v. Attorney General for Northern Ireland and R.V. Sullivan, sleepwalking R.V. Burgess and hyperglycemia arising from diabetes in R.V. Hennessy. Where the defect of reason is caused by an outside source, this will not lead to a finding of insanity, but may give rise to the defense of non-insane automatism. This has led to an unfortunate consequence in relation to diabetics, since if a diabetic commits an offense whilst suffering from hyperglycemia, a state arising from too much blood sugar as a result of not taking insulin, they will be classed as insane according to R.V. Hennessy. However, if the diabetic takes too much insulin resulting in a hypoglycemic state, this will be classed as an outside source resulting in a finding of non-insane automatism according to R.V. Quick. Non-insane automatism is a complete defense leading to the acquittal of a defendant with no hospital order attachments. External factors such as drink or drugs also may lead to a finding of non-insane automatism according to R.V. Burns and R.V. Roach 2001. The third element of insanity under the M. Norton rules is the defect of reason must be such that the defendant did not know what he was doing, or, if he did know, he did not know the act was wrong. If the defendant knew that what he was doing was unlawful, no finding of insanity can be made even if they did not believe it was morally wrong. In R.V. Windle, 1952, the defendant gave some aspirin to his suicidal wife, killing her. He then called the police. When they arrived, he stated, "I expect they will hang me for this." This showed he knew that it was unlawful. It did not matter that he believed it was morally right to assist his wife. In summary, where a defendant is found not guilty by reason of insanity, they incur no criminal liability, but may be detained in secure accommodation for an indeterminate period. The Norton rules apply to establish insanity. The defendant must be suffering from a defect of reason caused by a disease of the mind, so that they did not know what they were doing, or, if they did know, they did not know that it was wrong. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.